Hi, everyone. Thank you for joining the fourth session of Transform Startup and Scale Up, and welcome. My name is Pierangelo Rosati. I'm Assistant Professor in Business Analytics here at DCU Business School, and I will be your MC for today's talk with Dr. Katherine O'Keefe. As you may know, the Transform series is a new series of free online webinars that explores the growing impact of digital transformation on business and society. We'll be covering a total of 6 areas ranging from the future of work to smart cities and communities to the circular economy and many more. Today, we are looking at the second of these areas by focusing on the role of digital technologies for startup and scale-up companies. We are delighted to be joined by Dr. Katherine O'Keefe, Director of Education and Training at Castlebridge. She is also a co-author of the book Ethical Data and Information Management, Concepts, Tools and Methods. Today, she'll be telling us a bit more about her work in enabling digital transformation as well as GDPR related issues for startup and scale-up companies. Welcome, Katherine.
Thank you.
For our attendees, feel free to send your questions during the session using the Q&A function that you see at the bottom of your screen. You'll find that please be aware that the chat function is disabled, so only the Q&A tab works. We will compile all the questions at the end of the presentation, and we'll try to address as many of them as possible. With no further delay, I'll hand you over to Katherine. So Katherine, over to you. You should have control of your slides and so on, and I'll be in the background if you need any help.
Great, thanks. So today I'm basically going to be running through some of the essentials when it comes to GDPR and data protection and how that is very, very relevant to any sort of startup or scale up company, particularly when you're looking at anything relating to doing things with data that might in fact be data about or relating to people. So I'm a consultant and trainer. I personally have worked with quite a few startups, small companies, charities, as well as larger companies, utilities, transport companies, when it comes to looking at various types of data issues or problems that they might have and solving problems, finding solutions when it comes to trying to reach your goals and do the really cool, interesting things you would want to do with data in a way that is compliant. And does comply with European data protection law, and also ends up in a win-win type of a situation for companies so that they can be trustworthy and in fact work in ways that their customers want and that would look to be a good solution for people, create things that they want to buy in ways that are trustworthy. So when it comes to what we're talking about with data protection, again, a lot of our companies in the startup space right now are looking at using data in really, really interesting ways. But with anything that you do regarding to using data that could relate to people, you can affect people and do things in ways that have great types of risks. So European data protection law is risk-based. What it is doing is saying that we have a right to make sure that anytime people are using data that relates to us or is about us, information about us, that it's used in a way that mitigates risks to us, mitigates risk to harms to us. So the concept of data protection is based in the Charter of Fundamental Rights in the European Union. And it's saying that to protect all of our rights and freedoms, all the rights and freedoms listed in the Charter for Fundamental Rights, that when organizations process data, they have to ensure that they follow certain steps, follow certain rules to mitigate the risk to our rights and freedoms when our data is processed. So we have certain conditions that organizations have to follow, and we as data subjects, people who have information about us, have rights that the obligations are meant to protect. So one of those is privacy, but we're looking at a whole bunch of other rights as well. So data privacy globally, if you're looking at that, is one of the things that we're looking at with data protection. but the rights to health, rights to life, all of our various rights that we're looking at there need to be considered when we're thinking about what could the organization that we're building, what could the cool technology that we're developing, what could our data use possibly affect, how could it possibly go wrong, and how can we make sure it doesn't go wrong. So when we're talking about the types of company that we have, no matter what your organization is doing, you are handling data, and you will have a certain relation to the data. So in some cases, in many cases, you'll be a data controller if your organization decides the what and how of data is going to be processed. So all organizations are controllers of some things, for instance, their employees' data. That they decide what data is being processed and how in those cases. In other cases, you may also be a data processor. So a data processor is a legal entity that is contracted by a data controller to do a specific thing with data. So for instance, if you're using Amazon Web Services or another cloud service provider to store data, and it's specifically used for a certain thing that is in the contract, they don't do anything else with it, they're acting as a processor in that type of a situation. So a data processor only does what they are contracted to do with the data. If they do anything else on their own decision, they are acting as a data controller. So the body that or entity that has decision-making rights over what is done with data decides, controls the means and purposes of processing is what the legislation says. They are a controller. In some cases, you will have a joint controller relationship where more than one entity is acting as a controller in certain situations. So for instance, if you're using Facebook as a means of communication and advertising, you are going to be a controller of some of your clients' information in some cases, or you're going to be a controller of the information that you put into Facebook. If you put a Facebook like sign on your web page, you are going to be deciding that some data will be going to Facebook. So you're a controller there, but you don't have any control over what Facebook does with that data. So they are controllers in their own right as well. You are joint controller relationship. You have a joint controller relationship there. So what is required in all of these situations? A data controller is accountable for any of the data that they collect and that they process. So if they hire a data processor, they need to make sure they have a very clear contract putting in place all the various protections that need to be in place to ensure that that data is treated properly. They need to do due diligence to ensure that the data processor that they've contracted with will in fact be compliant themselves. When it comes to a joint controller relationship, you need to document the respective rights and responsibilities to ensure there's clear governance over that data so that you know what you're responsible and accountable for, and that you know what the other joint controller is responsible and accountable for. So I'm talking a lot about personal data. The first thing that we're looking at is what actually is personal data. This is something that can get a little bit confusing when you're talking to people from different parts of the world, because different jurisdictions have different definitions in their law. So personal data in Europe, we're looking at under GDPR, the definition is any information relating to an identified or identifiable natural person. Now that is very broad and it's very context-based if you consider how you can possibly single out an individual from a crowd and pinpoint this is an identifiable person. You don't necessarily know their name or have very, very clearly personally identifying information as your US law calls it. But if you can single out an individual from a crowd, that is in fact making someone identifiable from indirectly identifiable. So this is what we're looking at in the definition of data subject, which is a person, a identifiable natural person who can be identified directly or indirectly in particular by reference to an identifier, such as a name, identification number, location data, so on and so forth. So any sort of thing that can single out an individual from a crowd, that can pinpoint that is a single person rather than any other person, that is personal data. So what we're looking at here is the importance of context and the importance of understanding what other information can be connected to the data that you have to give more context and single out that is a person. So you do have to consider all the objective factors. You need to consider what the context is, and you need to be able to consider what the risk is of re-identification. So when it comes to any sort of data analytics, this is something that you're going to need to be considering. What is the risk of possibly re-identifying an individual from the large amounts of data that you may have gathered? So we have personal data. We also have special category personal data, which is data that has been clearly identified because of various horrible things that have happened in the past, things that have gone wrong, discrimination, oppression, or other sorts of things that would be of a higher risk to people or their fundamental human rights. So anything relating to racial or ethnic origin, political opinions, religious philosophical beliefs, trade union membership, these are types of things that if you wouldn't be able to ask these questions on a job interview, they're definitely special category data. They're the type of thing that you have to put higher restrictions around the use for it because there is higher risk involved in processing this data. So similarly, genetic data, biometric data, for the purpose of identifying a natural person, this is considered to be special category or higher risk data. Similarly, data concerning your mental or physical health, your sex life, or your sexual orientation. So special category used to be called sensitive. There are other types of data that may also be sensitive. For instance, financial data that you would consider to be a higher risk, but they're not necessarily special category. But again, if there's a higher risk, you have to be much more careful about how you're using this data. So processing, basically, if you're doing anything at all with personal data, you are processing data. That includes looking at it, accessing it. It includes disclosing it, storing it, and it includes destroying it, getting rid of it. So erasure or destruction is also processing. The only way to not process data is to not have it at all. So very, very long list in the definition, but basically if you're doing anything at all, if you have data, you are processing data. Another useful concept that is new in GDPR as far as a legal concept is the concept of profiling. And the reason I'm highlighting this is it is different from the way that we talk about profiling in a lot of other contexts. So any form of automated processing consisting of using data to evaluate certain aspects relating to a natural person, specifically if you're looking at analyzing or predicting their behavior, performance at work, preferences, interests. So a lot of the type of things that go on when it comes to the analytics that we have would be considered to be profiling. So profiling is something that you need to be very careful of because it can very quickly reveal special category personal data. If that is the case, you do need to be extra careful about what you're doing with it and how. So any sort of automated decision-making in profiling is only allowed under very specific conditions if you do have special category data involved, and you need to make sure that you are in compliance with GDPR when you're looking at this. So again, this is very important if you're thinking about anything relating to big data or analytics. So the core of data protection is that we have obligations to ensure that we follow these principles here to be very careful to ensure that we are considering what risks there might be in how we're using the data and that people understand what is happening to data about them. So fairness, lawfulness, and transparency is the first of our core data protection principles. It's basically saying that you need to have a clear, lawful basis for doing the processing that you're doing, and people need to know what's happening to data about them. So fair processing basically means that you have told people what you're going to do with their data, and you only do what you told them you're going to do with the data. So there should be no surprises at all. People should understand what's happening. So in order to be fair about processing data, you're also going to be transparent in telling them what you're going to be doing with what data about them, for what reasons, and making sure that they understand why you're legally allowed to do this. So purpose limitation is, again, based on this concept of fairness as well, and that you are processing data for a specific lawful purpose, and you've collected that data for that specific lawful purpose, and you're only using it for that purpose. You're not going off and doing something else completely with it. So again, what that means when you design the things that you're going to be doing with data, when you design your processes, when you design your systems, you need to understand and communicate what you've collected that data for, how you're going to be using it, and what is compatible with that purpose, and only use it for things that are compatible with the purposes that you collected it for. So repurposing data that is relating to people can only be done if it's done in a fair, lawful, transparent way, and people understand that that is happening to their data. Data minimization as a concept is making sure that you only collect what is relevant and necessary for the purposes that you're processing the data for. So you collect what is necessary for your purpose. You make sure that you have adequate data for completing your goals, but you don't collect everything just in case. Accuracy, again, it's making sure that the data is relevant to the purpose and that it is fit for that purpose. And it doesn't go out of date. So it makes sure that you have good quality data for what you need to be doing. Storage limitation is making sure that you only keep data as long as you need it for your purposes, and you don't store it indefinitely for however long, leaving it at risk of breach and other issues. Again, if you have data that's kept very long, often it becomes of very low quality, less use to you, higher risk to the data subjects and to your organization. Integrity and confidentiality as a principle is your information security principle largely. So it's making sure that you process data in a manner that ensures it's kept appropriately secure, protected both against unauthorized disclosure, but also unauthorized or unlawful processing, making sure that you back things up, making sure that you test your backups, that you have robust systems, and don't inadvertently lose or have destroyed the data as well. So it's protecting not only against hackers, loss, or unauthorized disclosure, but it's also ensuring that you have robust systems and that the data is available to you for your purposes. And the final principle is the accountability principle, which is that in order to be in compliance with data protection laws, you not only have to be able to follow these principles, but you have to be able to demonstrate what you're doing in order to follow these principles. So what that largely means is that when it comes to making sure that you have designed your processes, you document your decisions, you document what you're doing in order to be in compliance. Now, as far as the lawfulness, fairness, and transparency principle, that lawful question, there are various reasons that we are able to process people's personal data. So again, it's not only on the basis of consent. We have 6 main lawful purposes for processing data, lawful conditions under which we can process data. So in some cases, it will be consent. The data subjects have agreed to let you process the data. And they, in that case, you need to make sure that you can document that it is valid consent, that they have given it freely, that they understood what they're consenting for, and that it is unambiguous. It's clear that they actually have consented, and they can withdraw that consent at any time. It's fully informed, freely given, unambiguous. In other cases, you're not going to be relying on consent at all. For instance, generally, when you give your financial data to your employer, it's not on the basis of consent. It's because in order for your contract with them to be completed, they need to be able to pay you. So performance of a contract is one of the other main ways by which you can lawfully process data. So if it's necessary in order to complete a contract that you've entered into, or that necessary to enter into a contract, then you can process that data. Similarly, we don't give our data to revenue on the basis of consent. We do that because we're required by law to pay taxes. So if you're required by law, you're under legal obligation to process the data. That is on itself a lawful basis for processing data. Vital interests are if somebody's life or health are at immediate risk. So if you need to, call the guards or call the emergency services because you're seeing someone at risk, you don't have to wait for consent to process their data, to give that information. You're doing it because it's in their vital interest to do so. Now, a lot of what the government relies on when they're processing your personal data is they have a legal basis under official authority, generally in the public interest. Now, the sixth and final of the general lawful basis for processing data is legitimate interests. So for instance, it's in the legitimate interests of organizations to be able to communicate to possible customers and other people like that in order to conduct business. So that has to be balanced against the rights, freedoms, and interests of the people that the business is trying to contact. So if you're going to use legitimate interests, one of the things that you have to do is document a balancing test saying, yes, here is our legitimate interest in using and doing this processing. Here are the possible bases that we have. On the other hand, here are the rights and interests of the data subjects whose data we're processing. We need to be able to prove that our interests override the interests of or more stronger than the interests of the data subjects to not have their data processed, and be able to show that here's how we're minimizing any impacts on the rights, freedoms, and interests of the data subject. So that's for general personal data. Again, lawful, it must also be fair and transparent. People need to know where the data came from, how you're processing it, what you're doing with it, and be able to object at any point. Special category personal data has further restrictions. So in general, if you're looking at special category personal data, because it is higher risk, it's prohibited unless it fits one of these very specific conditions. So the main one that you'd possibly be able to be relying on is explicit consent for a specific purpose. Again, if it's necessary for obligations and rights under Social Security, employment, or social protection law. Again, all of this has to be subject to safeguards and making sure that that processing is actually necessary and proportionate. But again, when you're processing employees' sick leave, health data is involved there, it is necessary under employment law to do that so that you are covered there. When it comes to the questions of vital interests of the data subject or a third party, if the data subject is incapable of giving consent at that point, and it is necessary in order to protect someone's vital interests, then you can use it there. Not-for-profits and charities have some situations where they can communicate with their donors, beneficiaries, other members of their societies, even if it is special category personal data. So for instance, churches can in fact contact their members, but they can't use it for that data for other purposes. They can't just publish it online. If data has been made manifestly public by the data subject, that data can be processed. If processing that data is necessary for legal claims and lawsuits, that's another lawful grounds to process data. On the basis of EU or Irish law, we can, in some cases, process data for reasons of substantial public interest in a proportionate way. This is one of the things that we're looking at right now for the contact tracing apps that we're looking at, because of course, when we're looking at questions of contagion and does somebody have COVID, that is data relating to health. So the Irish contact tracing app was developed in a way that was very, very minimizing of the type of data that they might be processing, but the processing of information relating to the pandemic there is necessary for a substantial public interest reason, and Irish health law does allow for it. So it is there, it is allowable. Similarly, if you are a healthcare provider, you're going to be, or processing data for similar reasons, you're developing medical apps. There may be necessary processing for the treatment of patients, or also when it comes to preventative or occupational medicine, that is allowable under specific law. When it comes to research, archiving scientific research or historical research, there are specific allowable ways to do that, again, because it is recognized that this research is in a public benefit. So there are very, very strong restrictions around when you can use special category personal data. And so if you go back to the definition of what is special category data, it's important, if you're doing any sort of analytics or things where you could possibly be doing something that reveals somebody's health, religion, if you're dealing with, for instance, location analytics, and you are able to identify that this person is regularly at a hospital, or this person is regularly at a church, mosque, or synagogue at a certain time on a certain day, you're doing something that reveals something about special category personal data. You have to be very, very careful with what you do, where, and how. So the accountability principle, like I said, it creates a positive duty to plan for and put controls into place in place around the use of data for specific purposes, so that you can meet your goals in a way that is compliant. One of the ways that you need to do this is what was called privacy by design. So in the designing stage of your developing your product, you need to consider what issues could arise at every stage in the data lifecycle, and make sure that you design your product in a way that can be compliant and that can have a win-win situation, so that your product works, and it works in a way that is compliant, that protects people's privacy, that protects their other rights, and ends up in a much, much better product that people are happier with as well. So it is a very, very good and useful design tool, as well as ensuring that you are in fact in compliance with the law. But what you need to do is you need to think about how you are processing data, whatever you're designing in your company, how it does handle data, how you process data, what types of data you are in fact going to be processing, where and how you're getting that data from, and make sure you can document what you do with that data, why, and what protections that you have around it. So basically, what you're looking at, no matter what sort of process you're designing, no matter what sort of product you're coming up with, you are looking at the W questions at each stage in the life cycle of your data, and making sure that you design into your product the ability to answer these questions, and the ability to make sure that people understand what data you have on them, what you're doing with it, why you're doing with it, the other thing that you're doing with it, whose data you're processing, understanding who touches what data, who has the authority to decide what happens to what data, and who has access to the data. When you get data, what data you get when you do that, when do you use the data, when does your processing conclude, when do you get rid of data, when do you delete data, where your data comes from, where it's processed, where it goes to, again, who has access to the data, who are you sharing the data with, and always understanding your purposes and your business need for processing that data so that you can have a clean and efficient system that optimizes all of your requirements and optimizes processing to meet your goals. And the big question with why is, if you can't answer any of these who, what, when, where, why questions about why do you have the data, why are you using it, the big question is, why do you have the data? So there are two types of tools that GDPR puts into place that can be very useful for helping design your product in a way that is in fact compliant. Now, the first one is the Data Protection Impact Assessment. And these tools result in documentation that the DPC, Data Protection Commissioner, will be looking for if anyone comes and has a question, or if they just are responding to any sort of complaint. So the Data Protection Impact Assessment is a risk impact assessment that you put in place in the design phase while building your product to identify possible risks to data subjects when it comes to the actual processing of data in your thing that you're building. So you identify risks, you identify how you're going to mitigate those risks, and then you document what you've done to reduce any sort of risk when you're processing data. The Register of Processing Activities is a documentation of the types of business processes you do in your organization that involve personal data. So that can be everything from the hiring process to the types of marketing and communications you do, but it's identifying your business processes, your activities that you do in your organization that use personal data. And it's mapping it, and it's making it clear that you understand where data is in your organization and how it's used. So those are accountability tools that we have. All these obligations that we have in organizations, whether we're a controller or a processor or a joint controller, is in order to protect people's fundamental human rights around their data. So we are also data subjects. We also have rights. So the first one is to understand and be able to access the data that organizations have on us. So organizations, when they collect data from us, are required to tell us what data they have, who they are, what they're doing with the data, all the who, what, when, where, why questions that we just had about data being collected on us. And we have a right to not only know what data they have on us and what they're doing with it, but we have a right to a copy of all of that data as well. We have a right to rectification of incorrect data. So this is the flip side to the accountability principle, the obligation that organizations have to ensure they have good quality, accurate data on us. If that data is inaccurate, we have a right to make sure that it's corrected. In situations where organizations have data on us that they don't actually have a lawful basis to have, if they're keeping it longer than they have a reason to, we have a right to ensure that data is erased. Again, none of these rights are absolute. They're balanced with other rights and obligations. But in cases where organizations, controllers, or processors do not have a lawful basis to continue to be processing the data, or our rights override their lawful basis to be processing that data, we have a right to make sure they erase it. In certain cases, we have a right to restrict the processing of information. So largely, this is in cases where the controller really shouldn't be processing the data, but we don't want them to delete it because it's, for instance, evidence that they've done something wrong. So we can have them hold it aside and only store it and restrict access to or processing in other ways until something is concluded. Another way in which the restriction right can be useful is if the accuracy of data is in dispute. So for instance, we complain and say, I complain and say, you have inaccurate information on me. They say, oh no, that's correct. In the meantime, while the accuracy of the data is being verified, we can have the data restricted until the accuracy is verified. In cases where a data subject puts in a erasure or restriction or a rectification request to a data controller, and that data has been shared on to other organizations, the controller needs to notify the recipients of the information that we've said, this is incorrect, it needs to be corrected, or that we want it to be erased. So it's making sure that that request goes down the chain, and also we have the right to know that it's been shared on and that request has been shared on as well. Data portability is one of the newer rights. A lot of these rights have been in law for over 30 years, so they're nothing new. But data portability is an extension of the right to access. So basically what it is if data is processed on the basis of contract, and if it's in electronic format. So think about, for instance, your social media records, or your insurance profile or something like that, bank records. You can have a copy of that material given to you to give to another data controller, or you can tell the data controller that has it that you want them to transmit it to another data controller in a standard, commonly readable format. So the main thing that this portability right really gets down to is a requirement for standards when it comes to personal data, so that data can be transmitted from one company to another without giving them proprietary formats that can't be read. When it comes to objection, we have a right to object to our data being processed. So the main way that we see this is when it comes to direct marketing. When you opt out or unsubscribe from emails, you are objecting to processing. So at that point, the data controller has to stop processing your data, which generally means they have to get rid of it. Or in the case of direct marketing, in many cases, it means putting a suppression on there so that your email doesn't get used for marketing purposes, so that they know they don't continue to email you. And then we have rights around automated decision-making. So if you've done much reading around things like the way machine learning and AI are being used in predictive justice, what it's called right now, or if you think about the various ways that automated decisions might affect things like your employment prospects, or other things that have legal or otherwise similarly significant effects on a person. This right is basically making sure that there's a human in the mix and it's not just a computer saying no. So we don't end up in a Kafkaesque nightmare where a computer has decided we can't get a job, or a computer has decided we're going to jail, but we don't know why. So it's making sure that when it comes to any of those significant effects, decisions cannot be made solely by a computer. So when it comes to things like putting in an access request, there is a time limit. If a data subject puts in an access request to you as a data controller saying, I want a copy of all my data, you have 30 days from the start of the request to get that all together and to make sure that you, redact any information that shouldn't be given. For instance, if you have information mixed in on another person, a third party person whose privacy or other rights might be impacted by disclosing that information to the person who put in an access request, you have to redact that information and before you give it to the data subject. So you have up to 30 calendar days to respond. That's calendar days, not working days. And you should respond as soon as possible within that 30 days. And you cannot charge the data subject for the time and effort that you have to put into gather together, collate, identify all the information that you have on them, and then ensure that you are disclosing it only to the person who the data is about, or someone authorized on their behalf. So very, very briefly going into some of the requirements around direct marketing. So this is, again, a place that a lot of people do process personal data about people, no matter what company they have. You kind of have to do a bit of marketing and advertising to get customers. So direct marketing, by the nature of directly contacting people, whether it's email, telephone, direct messages, if you're advertising, doing marketing specifically to people instead of broadcasting, then you are going to be processing personal data, and you have to make sure that you follow all those principles, fair, transparent, for a particular legal basis. Now, when it comes to direct marketing, we're not only looking at data protection law as far as GDPR, we are also looking at e-privacy law. So, again, all of this is based on fundamental rights law. The European level legislation that we're looking at is GDPR and the e-privacy directives. Directives need to be enabled in national law. So in Ireland, that's the statutory instrument 336 of 2011. There is a e-privacy regulation still in draft, so this will be a watch this space situation. We may have new legislation soon-ish, but it's been in draft for a few years now, so it's been a big question mark there. So when it comes to GDPR, like I said earlier, it's in your legitimate interest to market to customers. So you can either market on the basis of consent, or you can do direct marketing under legitimate interests. However, that's really only for postal-based marketing, because anything that goes over telecoms networks is also ruled by the e-privacy directive SI 336. So the e-privacy regulations require that electronic direct marketing, by email, by SMS, by that calls to mobile phones, by fax, only be done on the basis of consent. So you have to have opt-in consent in most situations for electronic direct marketing. So this is really the last slide here when it comes to electronic direct marketing or any other type of direct marketing. This is the flow chart for whether you can use legitimate interests or not, whether you can send the message. So if you have a lawful basis and it's postal marketing, then you just need to make sure that you're clear, lawful, transparent, that people that the data has been fairly obtained, and that people aren't getting surprise post. Because if they get surprise post, they will complain. I'm dealing with some complaints with clients right now, where what should have been a fairly obtained data for postal marketing accidentally had somebody's name that wasn't expecting it. So they complained to the client, and they're trying to sort out where that information came from and why somebody got post that they weren't expecting. But if you're doing any sort of electronic mail or SMS or phone calls to mobiles, if they've already bought something from you within the last 12 months, you're only marketing your own stuff, and you gave them the option to opt out of any sort of marketing at the point that they bought stuff from you, then you can still send them a message on the basis of legitimate interests. Otherwise, it has to be via opt-in consent. So you need to make sure that you have a very clear data trail of, yes, we got opt-in consent, or yes, we communicated to them that we will be using their email address or their phone number for this purpose, and gave them the opportunity to say no when they bought something from us. So one of the main things here is to make sure that in your customer database, in your CRM, you have very clear organization of your data. You have very clear flags in your database that say we are allowed to use this information for this purpose, and make sure that you can identify that, yes, I've gotten consent to use this for direct marketing. I can use this data for this purpose. So again, this gets back to the design. It gets back to communications so that people understand what they've consented to, and that you have clear design and modeling of what is allowed to be used with what data, under what circumstances, to ensure that you can use the data that you've collected and that you have to the, for as many lawful purposes as possible, that you are using it for the best benefit for your organization in a way that makes your customer happy and shows that you can be trusted with their data. So it all gets back to the who, what, when, where, why, how. Who you are, what you're doing with their data, why you're doing that, and how you're going to be using that data. Which means that you need to be able to communicate to people in a way that they understand, which means knowing who your audience is and how much information you need to be communicating them to their understanding, and being able to tell them what's happening with their data so that they understand they're happy to have you as a organization that is using their data. And largely that means that you need to have a very good understanding of what you're doing with information and how, so that you can communicate to them. So that's really it for the presentation. I'm happy to take questions at this point.
Thanks a lot, Katherine. That was very, very interesting. I think you have practiced a lot saying what, where, when, why, that part. I mean, I can definitely keep up the pace there. So for our attendees, if you have questions, feel free to type them in the Q&A function that you see at the bottom of the screen. And while we wait for a few questions to come through, I have one on my own. So based on your experience, what's the current status of startups and SMEs generally on their readiness, say, for GDPR, to meet the GDPR requirements?
Well, startups have a good position to be in, and because it is greenfield, you can design things in a way that is absolutely win-win. When it comes to older, larger organizations, they have lots of data. They haven't, they don't necessarily have clear, modeling. They don't necessarily have clear documentation of where they got it, what they did with it. So as a startup, you have the opportunity to build everything in a data protection by design manner. And in that way, you can absolutely do things right from the start. In many cases, when it comes to compliance, that question of is it going to actually be a large burden? It can be an advantage for startups at this point, because you can use the tools like a register of processing activities and specifically a data protection impact assessment to make sure you're building your systems and your processes in the most efficient way possible. And you're not behind the 8 ball, you're starting from the beginning. So you can do this in the design, planning and design phases, and before things start to go wrong. So it can be a big advantage over larger, older companies that have been doing things in a way that isn't necessarily compliant, and have a very, very large boat that's difficult to turn as far as that goes. You can be flexible. You can do things in a good way very quickly. It's making sure that you understand your data and your processes from the beginning. So we have a question here. Has there been any big spotlight cases of GDPR breach that were successfully prosecuted to date that we can give you an example of? Yes and no. So the wheels of justice turn slowly. So when it comes to prosecution, things are being held up under GDPR. The big prosecutions that the Data Protection Commissioner has started under GDPR so far, their first big targets have been the government, specifically when it comes to the Department of Social Protection. DASP now, sorry, Department of Employment Affairs and Social Protection, when it comes to the Public Services Card and the use of that. And then the other big ones that they've hit fines for have been TUSLA, the Child Protection Agency. Now, the DASP is in the process of appealing. TUSLA, there have been some big fines there, and there have been repeated fines that TUSLA has been hit with. Now, when it comes to prosecution in other cases, one of the things you want to look at with the Data Protection Commissioner is they don't want to actually start with prosecution. They want to start with getting you to do it right. And we can actually see this with Facebook already. So when it comes to the big tech companies, there have been preliminary rulings on investigations under GDPR for both Facebook and Twitter at this point. And those are in the process. We're not going to be seeing, necessarily the big headline fines as much because it doesn't work as well as the smaller fines and then repeated things that we're going to be seeing. Tesla's a good example of that. It's a smaller fine that was been given. It has been accepted. And because that same problem happened several times, that not necessarily humongous headline fine is going to be repeated several times. Facebook is in the middle of appealing under judicial review the findings. So we're still seeing that going on. But the more successful thing that we've seen that before you get to prosecution is some of the other powers that the DPC has, and that's telling Facebook not to do something. So last year, it was last year, 2019 Valentine's Day, Facebook was going to launch its new dating app in Europe. And they were told, no, you cannot do that. Where's your data protection impact assessment on this? Facebook couldn't actually give them a data protection impact assessment because they hadn't done one. And so the Data Protection Commissioner forbade Facebook from launching that dating app in Europe. So that's where you see more successful and quicker action, because when it comes to going through the courts, that is very slow. But the successful action, and as far as the DPC is concerned, the much more preferable action is to ensure that the bad thing doesn't happen, so it doesn't have to be prosecuted, so that they prevented something very risky and very dangerous from going forward at all.
All right, and then thinking about scale-up companies in the Irish context, if a company scales up, means that sooner or later they will hit the UK market. Mm-hmm. And as we all know, we are in an interesting phase of history in the relationship between Ireland and the UK, given all the Brexit deal and no deal. So what's going to happen from a GDPR perspective or from a privacy law perspective on the 1st of January for those who have business in the UK?
Okay, so there's a couple things there. The first one is that because you are assuming this is true, in compliance with GDPR, you will already have been hitting the gold standard when it comes to compliance. Now, the UK does have its own implementation of GDPR. They are keeping that. But some of their standards may end up lowered. And this is something that people in the UK are very concerned about when it comes to their own privacy rights and the trade deal that was just made with Japan, because it prioritizes data flows cross-border in a way that doesn't necessarily prioritize the rights of the data subjects in the UK whose data may be flowing across borders. But as an EU company, you have the higher standard that you are already going to be complying with GDPR. So that standard should be complied with when it comes to any of your UK clients who might be buying your services. What you will need is what's called a nominated representative in the UK. And this is a service that Castlebridge provides because we have a partner company in the UK that can provide nominated representative services for UK companies in Ireland. And so we've got the ability to provide nominative representative services for European companies selling to the UK and for UK companies selling into the EU and Ireland. But that's just a requirement in EU law, and it's also a requirement in the UK Data Protection Act. So you will need a nominated representative in order to sell into the UK post-Brexit. One of your bigger concerns probably will actually be any sort of service providers that you are using that are UK based. So again, whether that's data storage, other sorts of financial services providers, any sort of processor that you might be using that is based in the UK, transferring data of EU people, again, EU data subjects into the UK is likely to be extremely problematic after January 1st hits and they are fully Brexited, because they will not be an adequate country when it comes to protections around personal data. So UK customers who are buying your services as an EU business will be looking to have the strong protections of a GDPR compliant company. But if you're using a company in the UK to process your client's data, there will be problems there.
Okay, and am I right saying that essentially, if company is EU based and it's complying with GDPR from a privacy perspective, from a privacy regulation perspective, that company would have all the main processes that the company needs in order to comply with privacy law regulations across different, say, internationally, including the US? Because as far as my understanding is that essentially GDPR is probably the strictest and the most strict regulation from that point of view.
Yeah, the GDPR is considered to be the gold standard globally, and a lot of countries are now actually revising their data privacy or data protection laws to make sure that they have up their standards to be closer to the gold standard that is GDPR now. So there's actually some really interesting privacy and data protection legislation going on in various African countries right now. Some of them very strongly based on the rights principles that those African countries have. But when it comes to global standards, you're looking at GDPR and you're also looking at the Convention 108 Plus. So that's the only binding international treaty that we have when it comes to global data privacy. So it's definitely worth looking and seeing what countries are ratifying Convention 108 Plus.
And one thing that that the US has had for many years, and it was introduced in Europe just for, say, in the context of GDPR, was the mandatory disclosure of data breaches. I don't think that's been mentioned anywhere in your talk, and apologies if I missed it. But can you give us a bit more details on that requirement?
Yeah, so that is actually something that is for European data protection law new in GDPR, but was a code of conduct that was required under Irish data protection law for several years before GDPR. Was if you do end up having a data breach, you must notify, if there's any sort of possible risk to the people whose data was breached, you must notify the DPC within 72 hours of discovering the breach. And in most cases, you will need to also notify the data subject. This is not something, because I'm trying to cram a whole lot of information into a 40-minute presentation, not something I stuck into the presentation as a whole. This was something that California privacy law actually started with, if I remember correctly. As a proud Californian, I'm happy to say that. But it was an innovation in largely in I think Californian and Canadian privacy law before it was implemented into Europe-wide data protection law with GDPR. And when it comes to looking at comparing US and EU privacy and data protection regimes and legislations, the US is increasingly becoming a global outlier because it has a sectoral approach, but it's also a good example of why the general data protection, the globalized approach that Europe has is very good, because there are some extremely good pieces of legislation on privacy in particular states or looking at particular sectors. And so, when it comes to things like medical privacy law, data privacy law, people know and understand HIPAA because it was very well publicized. It was a good, strong piece of legislation for specifically medical privacy. But it's only for that sector and it doesn't cover a lot of bodies. So there's a lot of things that slip through the cracks. People now know GDPR, but when I started talking about GDPR in 2016 in particular, and getting people in the run-up to complying with GDPR here in Ireland, I would give a very long presentation on here's what GDPR is, and then people would ask, well, what about HIPAA? What about medical data? And like, medical data is covered. That's special category personal data. You don't need to worry about separate pieces of legislation. You have one regulator you need to worry about. You have two pieces of legislation you need to worry about, GDPR and e-privacy. That covers everything. So you don't need to worry about each specific sector.
All right, and then another aspect I think that few people might have questions about is relation to the need for a data protection officer. I mean, what are the requirements from this point of view for organizations when someone will need a data protection officer, and where can we find one?
Okay, well, if you need advice on that, Castlebridge is a consultancy and we offer data protection officer support services. So in many cases, if you have any sort of, again, large scale processing of personal data, again, if you're doing, a lot of startups do actually have large scale processing of personal data if they're doing cool, fun things with data analytics. You will need a data protection officer. Again, that is someone accountable for ensuring that you are asking these questions, that you are also the liaison between your customers, the data subjects, and the company. So you're that single point of contact. But a DPO cannot have a conflict of interest. So you can't, for instance, be the project manager who is required to make sure that you can get get your projects out and out on time and under budget, and also be the one who's saying, no, wait, hold on a second, we need to make sure we do this right at the same time. So similarly, if you're the CEO, you might have a conflict of interest there as well. So if you have a situation where you have a conflict of interest, you cannot be the fully the DPO. So that can be a big issue in small companies where you only have a few people there. So it's one of the things that GDPR allows is that you can contract with someone else to give you that DPO service. There are various specific things when it comes to the requirements for possibly having a DPO. One of those, if you're doing large scale processing of personal data, particularly if you're doing any sort of consistent or large scale processing of special category personal data.
All right. Thanks a lot, Katherine, for trying to summarize what you said earlier was a half day or full day course, at least, into 45 minutes. That was great. I really appreciate it. And before wrapping up, I would also like to thank our attendees. And then for those interested, there is one more session on Transform, Startup, and Scale Up taking place tomorrow at the same time. So starting at 1 p.m. Tomorrow we will have a panel discussion with Daniel Kane, founder and CEO of OpinionX, Kira Shenan, founder of ORB Media, and Wendy Slattery, co-founder and CEO of Beauty Buddy. Also, for any DCU students that are on this call, just to let you know that DCU holds a weekly startup clinic for students who have commercial or social business ideas. If you're interested, you can contact Terence Bowden at terence.bowden@dcu.ie for more information on the clinic times and how to access them. Transform the series will also continue on December 7th to December 11th with a new session on a new mini conference focusing on the future of work. So make sure that you keep an eye on our social media channels and website for news and registration. In the meantime, stay safe, and thanks again for joining, and thanks, Katherine, for your valuable time.
Thank you.